You're listening to Wiley's Political Law Podcast, a series of podcasts on election law, ethics, and government investigations. In each podcast, attorneys at Wiley, a Washington, D.C. law firm, break down an aspect of the political law landscape with our unique insight into issues faced by our clients.
Welcome, everybody. This is a podcast of the Wiley's Election Law and Government Ethics Practice. It's Mark Renaud and Andrew Woodson. We're both partners in that practice. Today, we're going to talk about a timely topic, which is the top 10 effects of primaries in election years. How does it affect the campaign finance world? And with that, I'm going to hand it over to Andrew to start us out because we've got a March 1 primary in Texas and we've got Indiana and Ohio primaries on May 3rd. So Andrew's going to start us off with the most obvious and direct impact of primary and primary days.
Thanks, Mark. I'm going to talk about one of the most obvious ways that the campaign finance laws change around the primary period, and that's through something called the electioneering communications. I think most of us know that the Federal Election Commission regulates communications that are very explicit in their electoral messaging, i.e. those that say vote for, vote against, defeat so-and-so. But one of the changes that was made about 20 years ago or so in the McCain-Feingold legislation was to also regulate a type of communication called an electioneering communication. And at the federal level, these are ads that are run 30 days before a primary election, can be run 60 days before a general as well, but here today we're focused on the primary period. And they're run on radio or television, and they're targeted to a particular jurisdiction where the candidate is running. So if you're running an ad in Washington, D.C. that mentions Nancy Pelosi, we're not talking about that. We're talking about something that would show up on television in her home district in San Francisco. And the key is that, again, that the ad mentions or features a candidate or political party. So it's run within the particular window, it's run on a particular medium, radio and TV, and then mentions or features a federal candidate. And when you run those types of advertisements, you have certain things that come along with that. First of all, you've got to have a disclaimer on the communication, both a written disclaimer indicating who paid for the ad, provide information about the website, street address, phone number, point of contact for the organization that's running the ad. And then you also got to have an oral disclaimer stating that such and such organization is responsible for the content of this particular advertising. In addition to including the disclaimer, you've also got to report the amount that's spent on this particular type of communication. You do so on an FEC Form 9, which is filed if spending exceeds $10,000, and you must do that within 24 hours when the communication is disseminated. And as Mark alluded to, the windows for having to file these types of reports and for these types of communications becoming an issue are quickly coming upon us.
Right. So the electioneering communications are about communications that don't expressly advocate the election or defeat of a candidate. And they're also about running the ads generally. But there are rules about coordination with candidates. So if someone coordinates certain types of public communications with candidates or political parties or their agents, then the resulting communication, the value of that communication could be an impermissible contribution if it's done by a corporation, or an excessive contribution if done by a natural person or individual. And the only time that the coordination comes into play is within the coordination time periods, which again are keyed off of elections, including the primary. So 90 days before a congressional election, which includes the primary, third-party speakers, so that could be any type of organization, may not coordinate certain communications with the candidate, a candidate's campaign, or a political party, or their agents, so that they don't have an impermissible or excessive contribution. So, for example, for the March 1 primary in Texas, we're already within this 90-day period. But it doesn't apply to everything. So if you just ran an ad on TV or put some ads on the internet that said, we want the president to veto this bill, you could coordinate that ad in particular with a candidate or a member of Congress who's running for re-election. But you couldn't coordinate it if it said, call your senator and tell her to vote against this bill you couldn't coordinate it with that senator or that senator's campaign if the senator is up for re-election and in that primary in the next 90 days. So a public communication that targets their jurisdiction, such as paid ads, internet ads, letters, TV, radio, billboards, things like that. Also, other kinds of communications would be electioneering communications. So within that 30-day time period, that pre-primary time period Andrew spoke about, you couldn't coordinate those with any candidates that are in those ads or with their political parties. And of course, express advocacy. So if you had an ad that said, vote for, vote against a candidate, you're not going to be able to coordinate that with the particularly impacted candidate or political party or their agents. So, if you can't talk to their consultants, et cetera, as well.
And then the third thing I think it's important for people to understand, just to take a step back for a second, when talking about the work that you might be doing with elected officials, either on television or bringing them out to your facility, for example, there's going to be a lot more scrutiny by regulators about those types of activities during the pre-election periods for the primary, and during an election year generally, but particularly during these pre-primary windows. So, for example, if you want to have a senator or your local congressman come out and tour a factory and meet some of his or her constituents and talk to line workers on the factory, that's great, but they need to really stay kind of on script in terms of, if this is a visit when they're coming out in their official capacity, they should be talking about official government business. They shouldn't be using this as an opportunity to campaign and tell people to vote for him or her in particular issues. As a lot of times, stories about these types of visits do get publicized, and you and your organization want to be in a position to be able to say, no, Senator so-and-so was really here just to meet with people and talk about issues of interest to our workers, our company, et cetera. This was not a campaign visit at all. And that principle also applies to issue advocacy. If you are running ads and you're trying to lobby legislators, Congress is in session during a lot of these pre-primary periods, and your organization might have a lot of things that it's interested in pushing in Congress. You need to be really careful about the types of communications and the words that you use in the ads, because regulators are going to be more skeptical in a number of cases about whether you as an organization are really trying to advance a policy objective, or is this some kind of advertisement that is masquerading as an issue ad, but it's really about trying to help somebody get across the finish line for a primary. So when we work with clients, we are particularly attuned and think through, okay, well, how might a regulator perceive a particular communication? Are there ways to make sure, again, if it's intended to be an issue ad, that the regulators will understand that in fact is really what's the case here, and you don't want to have a court or regulator, somebody down the line, particularly if you're not trying to make a campaign communication, to have a reason to really second guess what the communication is really about. So from a high level, those are some of the things, particularly when interacting with people and advertising, some of the key things to think about.
So we're up to number 4 and channeling our inner David Letterman here, 4 out of 10. And a lot of folks who are running PACs, whether they're non-connected PACs or separate segregated funds or corporate PACs of trade associations or corporations, they have the option every year of filing on a monthly basis or on a quarterly / semi-annual basis. So in an election year, the option is monthly or quarterly. And that's great to choose between those. But if you do decide to file quarterly, primaries can have an impact on that, because if you file quarterly and you make a contribution between the close of the books for the last quarterly filing and the close of the books for a pre-primary report, which is 12 days before the primary, that's when the report's due, so the closing date's a little further out, then you as a PAC may unknowingly trigger a pre-primary report of your own. So all the candidates that are in a primary have to file a pre-primary report. But you may trigger, by making a primary contribution during those time period, a pre-primary report of your own. And we have a couple clients every cycle that this happens to, and they get a little letter from the FEC, and you might even get a civil penalty for not filing if they miss it altogether. So the FEC is not going to tell you. They don't know when you made your contributions, but you got to remember that. And if you don't want to have to deal with this issue, make all your contributions in 2022 to the general, if you can, if you don't run up against limit problems, or switch to filing monthly in election years. And of course, filing monthly is good for other reasons too. It's fewer dollars to reconcile, and it's more habitual. It gets people in the habit a little bit better of making their filings.
The other reporting requirement that changes for folks are those that make independent expenditures. And these are the reports that you may file using FEC Form 5. And normally, if your organization is making independent expenditures and you are making them in amounts of $10,000 or more, you've got to file those reports within 48 hours. But when you get into certain pre-election periods, and in this case, again, we're talking about the primary, so 20 days inside the 20-day period before a primary, the reporting threshold changes. And instead of a $10,000 threshold, it's a $1,000 threshold, and you've got to file those reports quicker. So instead of 48 hours worth of time to be able to file a report, the window shrinks down to 24 hours. So it's something to keep in mind. You got to be a little quicker getting those reports in. Potentially you have to report more activity. And these will start as soon as I think February 10th, because the Texas primary is coming up and the 24-hour period begins on February 10th. So those are the important reporting changes to keep in mind as we get into the primary season.
So number 6 is a little bit different than reports or disclaimers or anything like that. It's really more of a practical idea of how primaries impact the campaign finance world. And that's that, the public and customers and their workforce, everyone is more engaged. I mean, some people are never going to be engaged, but people who are more engaged in political ideas and actions around the time of the primaries and around the time of the general election, right? There's ads that force them to pay attention, even if they have ad blockers. There's ads on the internet, there's Facebook ads, etc. And so, you need to take this into account for, government relations purposes and PR purposes for your company, your trade association, that people are more engaged. It may give you more room to maneuver, or it may box you in depending on the state or the, what congressional districts around your headquarters are doing or things like that. Kind of related in that way because, some part of your workforce is more engaged. Maybe the executives are more engaged in these political ideas and political activities because the elections are upon us. Because of that, often a lot of our corporate PACs and trade association PACs decide that it's a good time to fundraise and put out why it's important to give to the PAC because of that the PAC supports candidates that support these ideas and these issues. And if if the timing's right and the atmosphere's right, that can help drive increased contributions because folks want their candidates to win, and they want candidates to win who are looking out and cognizant of issues that are important to the company or the trade association. On a different point, number 8 here of the top 10 ways in which primaries affect campaign finance is that there is a lot more fundraising and by candidates and party committees and maybe other kinds of PACs. And for those entities, those government contractors who contract with state and local governments, and those folks in the financial services industry that work for state and local governments, you've got to remember that you've got pay-to-play issues every time one of your covered employees or officers or directors make contributions. So you need to make sure when the primaries start, early ones if you're headquartered in Texas, or middling ones if you're in Ohio and Indiana, and later ones in the August time period, depending on where your workforce is located, you need to be reminding them that they've got to pre-clear their contributions, and that they're subject to these provisions so that the company does not lose a current contract or get precluded from future contracts for 2 or 4 or more years because one of the covered folks made an impermissible contribution under the pay-to-play laws. And then finally, also related to pay-to-play laws, for those covered by the SEC rule, so the investment advisors, the swap dealers under the CFTC rule, the broker-dealers subject to the FINRA rule, the municipal advisors and municipal underwriters subject to the MSRB rule. All of those rules, which are, very strong pay-to-play laws, They have de minimis amounts. For the SEC rule, it's $150 per election if you can't vote for the person, $350 if you can vote for the candidate. But those are per election limits, and they reset when the primary is taking place. So once the primary is over, you are allowed under the de minimis, although still following your employer's pre-clearance process, but hopefully you'll be allowed to make another de minimis contribution after the primary, because those de minimis amounts are per election.
Yeah, and the last kind of point, of particular relevance to the candidates out there, is that if you are a winning candidate in your primary, all the money that you have amassed potentially before the election that has been designated for the general, after the primary election, you're now free to spend those funds to help your campaign for the general election. So I think many of you know, prior to a primary election, those funds that you might receive that are designated for the general, those are largely off limits for you to be able to use for the primary campaign. But if you're a winning candidate, you can tap those funds and spend away to your heart's content. And with that, that is the top 10 things that we thought might be helpful to folks who are out there getting ready for the campaign election season. Appreciate you all listening in today. And if you have any questions, both Mark and I are available to answer those in the year ahead.
Thanks very much, Andrew. Appreciate it.
Thank you for tuning in to the Wiley Political Law Podcast, brought to you by the attorneys at Wiley Ryan LLP. If you enjoyed this episode, we encourage you to follow us on SoundCloud. For additional resources and materials, head over to wiley.law. Thank you for listening. The views, information, or opinions expressed during episodes are solely those of the individuals involved and do not necessarily represent those of Wiley Ryan LLP and its employees. The material contained in this podcast is not intended to be and is not considered to be legal advice. Transmission is not intended to create and receipt does not establish an attorney-client relationship.